Let's start. The judgment of conviction and sentence recorded by the 14 additional CMM Bangalore in a proceeding under Section 138 of the Negotiable Instruments Act 1881 within the Act for Brevity upheld by the lower appellate court is under attack in his revision petition. Parties will be referred to as per their ranking before the trial court. The complainant, after issuance of a statutory notice to the accused, lodged a private complaint under Section 200 of the CRPC before the jurisdictional court alleging offence under Section 138 of the Act against the accused. His case was the accused numbers 1 and 2 within the husband and wife purchased immovable property residential site in a revenue land. Towards the part payment, he issued a check dated to 20/02/2009 for rupees 12 lakhs drawn on SBM Lingarajapuram branch, Bangalore, and the check was presented by the complainant before his banker. It was returned with the endorsement exceeds arrangement. The legal notice or the given notice sent through RPAD and UCP dated 26/08/2009 is served on the accused on 04/09/2009, but he failed to make payment of the check amount. The accused was procured. His plea for the offence under Section 138 of the Act was recorded and he pleaded not guilty. Complaint laid the evidence of himself as PW1 and a witness as PW2. After the closure of the complainant's evidence, statement of the accused under Section 313 of CRPC was recorded. He laid rebuttal evidence as PW1 and marked document exhibits D1 to D5. The trial court, on consideration of the evidentiary material placed before it, held the accused guilty of the offence, convicted him of simple imprisonment for 1 year, and acting under Section 357 within the 3 of CRPC. First, the accused was directed to pay compensation of rupees 19.20 lakh, out of which rupees 5,000 was to be deposited as a fine. In the appeal, the lower appellate court refused to interfere with the said order. Sri Sunil Rao, learned counsel for the petitioner of the accused, submits it was the case of the complainant that he had entered into memorandum of understanding within the MOU for short with the accused, wherein accused had undertaken to pay a sum of rupees 15 lakhs upon the performance of certain conditions numbered under said MOU exhibit P10. It was the cross-examination admission of the complainant that the contractual obligation was not complied with. Even otherwise, it was not within the domain of the trial court to investigate whether the contract between the parties had been satisfied. Thus, the courts below aid in coming into conclusion that there was a debt owed by the accused to the complainant. As per the sale deed exhibit D1, under which PW2 sold the property to the accused, inter-sale consideration was paid to the complainant. It suggests that the complainant was indirectly holding the property in the name of PW2 and has taken benefit out of said transaction. PW2 has categorically admitted during cross-examination that the inter-sale consideration under exhibit D1 was given to the complainant and he did not receive even a single rupee under the said transaction. Learned counsel continues, it is the case of PW1 that to avoid payment of stamp duty, the sale consideration was shown as rupees 8.75 lakh instead of purported consideration of rupees 26.50 lakh. PW2 admit that money claimed by the complainant was accounted money to the registered transaction, but this fact was lost sight by the trial court. Sri S. Rajprabhu, learned counsel for the respondent, in his reply submits the case of the petitioner is the accused agreed to purchase the property which was under the ownership of the complainant, and a sale agreement was entered into on 2012-2007 for a sum of rupees 26.50 lakh and rupees 6.50 lakh was paid in advance through check, agreeing to pay balance rupees 20 lakh. Yet at the time of registration, it was on the request of the accused, the previous landlord Robert Raj joined for execution of the sale deed. The complainant signed the document as a witness on the request of the accused. Sale deed was shown as rupees 8.75 lakh as government value to avoid stamp duty. The check for rupees 1.5 lakh was paid to the complainant toward the outstanding liability, and the accused had a short time of 6 months. Thereafter, MOU was entered on 21/02/2008 as per exhibit P10. On 15/08/2008, when the complainant demanded money, the accused paid rupees 5,000 in cash and issued issued another check for rupees 50,000 towards part payment and short time for the balance amount. When he approached the accused stated that he will clear the documents by himself and get transferred in his name through some agents and requested another 6 months time. The accused took for rupees 12 lakhs, deducting rupees 3 lakh towards documentation charges and assured to repay the balance once the formalities are completed. Top para. Thank you. Jai Hind.